Establishing carrier liability in international transport. The most common cases of carrier liability are theft of goods, delay in delivery, damage or deterioration, loss or failure to deliver. Carrier liability, International Consignment Note or CMR in road transport. According to the rules of the Geneva Convention regulating international transport, the transporter is liable for the goods carried in case of delay in delivery, total or partial loss, degradation occurred between collection and delivery. International Consignment Note: how it works and what is the use in road transport of goods. Carrier liability: the CMR Consignment Notes is a document certifying that the goods transported are collected by the carrier in a country and are to be shipped and delivered in another country. The documents support the contract of carriage for an international journey, which is drafted by the sender or the carrier and countersigned by the carrying courier. The consignment note is deemed as proof of the agreement on the carriage of goods between the two parties, determine the modality and condition of the operation performed, which must adhere to the International CMR Convention. The uniform regulation stated by the CMR has been largely inspired by the norms regulating maritime and air transport. To sum up, the consignment note regulates the contract for the international carriage of goods by road and intermodal transport, especially regarding the documents used and the carrier's liability. General clauses of exclusion of carrier liability. These are different types of carrier liability. Strict liability, whereby the carrier cannot produce any proof in their favor. Presumptive liability iure tantum, whereby a favorable proof is admitted. Only one reversal of the burden of proof is admitted. Cases where the classic rule of ex recepto liability will determine the judgment. Objective liability for infringement of the contractual obligation towards the goods collected. According to CMR, however, carrier liability disregards the concept of negligence and doesn't identify with the hypothesis of objective liability. Either Article 17.2 of the Geneva Convention states cases in which the carrier is relieved of liability. Liability of the carrier in international transport according to CMR and to the Civil Code and compensation limit. When ascertaining liability of the subject performing the transportation, it is useful to remember the following. Case law has equalized gross negligence to intention when it comes to carrier's liability in international transport. The theft of goods can be deemed as fortuitous even only when absolutely inevitable. The compensation limit is inactive in those situations depending on the carrier's reckless conduct. The application of CMR is only effective when expressly mentioned by the parties in their contractual agreement. Carrier's responsibility as per Civil Code Article 1693. The carrier is responsible for loss and deterioration of the goods collected for transport from the moment of reception to the of delivery to the recipient. They can be relieved from liability if able to prove that the loss or deterioration of the goods have been caused by fortuitous event, their packaging, the nature or faults of the goods themselves. If the carrier unreservedly accepts the goods to transport, it is presumed that no visible packaging fault is present. This rule configures an ex recepto liability as it stemmed from the collection of the good. Legal theory places contractual liability aside the extra-contractual liability. The norm emphasizes a particularly strict responsibility and states that the relieving proof doesn't operate negatively. That is to say, the carrier doesn't have to demonstrate to have used due diligence, but must prove the cause of the loss or deterioration among the ones stated, delivery to subject other than the recipient, fortuitous event or other event completely unpredictable and inevitable by the carrier, a lightning that sets the goods on fire. Loss of an easily perishable good which is already partially deteriorated good, immediate indication of the goods being deep frozen and therefore in need of particular care in handling. How the compensation system works for the carrier. Once the carrier's subjective responsibility for infringement of the obligation towards good in custody is ascertained, they will have to pay the entitled party a compensation. The compensation system set by the Regulation on International Transport is organized according to the reintegration of the asset of the party damaged by the loss or deprivation of the shipment according to pre-established standards. This regard, the international legislator introduced rules which were already valid for maritime ship owners' liability and the limit of the carrier's risk to a maximum amount per kilogram of transported goods. The role played by the compensation limit has proved to be pivotal in ensuring dynamic transport and adequate compensation given the ratification of Convention of Uniform Regulation everywhere in Europe. The value of the carrier's compensations for the goods. Compensation is calculated according to the value of the merchandise at the time and the place of receipt thereof for transportation according to a series of standards: the stock exchange course, the current market price, the usual value of the merchandise. A common principle in the uniform regulation is the exclusion of compensation limits when the damage can be ascribed to the toll of the carrier or to their behaviors lacking the minimum professional diligence required and that make them towed court responsible for the merchandise retrieved. In regard to that, when configuring the carrier's liability in international transport, the CMR reverts to causes of exclusion of any compensation limit according to special drawing rights to dole or negligence. In the Italian experience, the equivalent of dole and gross negligence is well consolidated in the field of good transport, so that compensation limit will not apply in all those cases of inexcusable negligence or omission to observe the minimum diligence. The problems related to protecting the owner of the goods in the international transport contract. The parties of an international transport contract are at least three: 1. The sender, owner of the goods; 2. The shipping agent that organizes the transport of the goods; 3. The carrier that transports the goods. However, it is often the case that between the sender and the carrier there is no contractual relationship, because the contract of transport is between the shipper and the carrier. Therefore, the owner of the goods will not be able to hold the carrier responsible for any loss or damage to their goods, failed delivery, and etc. Shipping agents' liability and carriers' liability. The Court of Cassation has already clarified that in a transport contract made through a shipping agent, the sender isn't entitled to hold the carrier responsible for any damage caused by the failure to perform the contract as per Articles 17 and 5, second paragraph of the Civil Code, which only legitimate those actions aimed at the satisfaction of credit arising from the exercise of the mandate. Thank you.